between copyright and design.
Kolhapuri chappal.
Most researching Indians can't afford.
Synthetically generated material.
Hi everyone. We have developments pertaining to copyrights and other intellectual properties that we have not discussed so far. Starting with the important decisions which were topically relevant this year, we have Karthik who will be discussing the first decision here. So over to you, Karthik.
Thanks, Praharsh. So the first copyright case that actually stood out last year is PPL Azure hospitality litigation. Now the underlying issue is about music licensing industry and whether the aggregator companies like PPL and Novex that we have that license out music for, let's say, various events like weddings, etc. Do they need to register themselves as copyright societies, or is merely having copyright assignments in their favor enough? Now, this question has been burning for a very long time. We have had multiple opinions from different high courts like Bombay and Madras. And last year in April, a division bench of Delhi High Court held that PPL cannot issue licenses for sound recordings without either registering itself as a society or becoming a member of another society. The court did an interesting interpretation of Section 33(1), which prevents any person or association from carrying on the licensing business without such registration. In its decision, the division bench ordered Azure Hospitality to pay royalty to PPL on the basis of the rates of RMPL, which is the only registered society for recordings in this regard. Now, the case is before Supreme Court via an SLP, and the Supreme Court has stayed the direction of the payment to be made to PPL as of now. And therefore, there is a bit of confusion right now as to how the division bench's reasoning is operating presently. And we will also need to see what are the implications of this particular litigation for other pending litigation between PPL, Novex, and let's say other maybe hospitality chains, etc., that is going on. So in that regard, I think we will be looking forward, and all eyes are now at the Supreme Court, because the final verdict on the interpretative question of Section 33 of Copyright Act will have to come from the Supreme Court. We have had enough confusion as of now amongst the High Court. Back to you, Praharsh.
Thanks a lot, Karthik. Now we have Bharatwaj who will be discussing two developments under this category. So over to you, Bharatwaj.
So I'll be focusing on two developments. One is with regards to copyright law. The other is with regards to genetically modified crops. Very diverse. But the first development with regards to copyright law is something that every listener or every researcher who is a listener right now would know by now, is the Sci-Hub order, wherein the Delhi High Court had banned access, I could say, to both Sci-Hub and Sci-Net for failing to abide by an undertaking which they had given 5 years ago. And the court decided to keep the undertaking in abeyance for 5 years without any substantial hearing. And the next substantial hearing where they discussed this, they decided that Alexandra, who is operating both Sci-Hub and Sci-Net, was in violation of the undertaking, and hence the service was banned. What had actually happened was that the court had compared Sci-Hub and Sci-Net to, let's just say, mirror sites or piracy sites that stream movies, and concluded that an interim injunction is necessary where these websites are not accessible from India. This, as you would know, has significant access cost, because in SpicyIP we have discussed so much about access to education, about the role of Sci-Hub played in access to education, how academic materials are behind costly paywalls that most Indians can't afford, most researching Indians can't afford. And the court's decision, unfortunately, does not factor into consideration all these concerns. It seems to be decided as if it's a private dispute between two parties, which here in this case it would be, on one hand it would be the publishers, and the other hand it would be the Sci-Hub or Sci-Net, which are considered as rogue websites by the court. And as Swaraj has pointed out and others have discussed, this will have significant access cost on Indian researchers, their ability to access good research. This development itself is in the category 1 because of this specific impact. And the second development that I want to focus on is Kritesh Oswal versus Union of India, which involved genetically modified crops. So a writ petition was filed before the Rajasthan High Court, wherein the major issue was, the allegation that was made was that there were genetically modified crops that were available in the Indian market, And the FSSAI, who is responsible for drafting regulations with regards to the conditions under which these GI crops has to be sold or vended in the market, is not available there. And GAC, another regulatory body who have been issuing regulations here and there with regards to sale of genetically modified crops. And this writ petition had sought the High Court to issue a complete ban on this, because the argument being that since the FSSAI did not have any rules, which means that the conditions under which the sale of genetically modified crops can be made is not there, hence no sale is allowed. And the Rajasthan High Court concluded that under Section 22 of the FSSAI Act, the FSSAI is required to pass regulations, which they have not, even though there has been a multiple discussions, even a parliamentary standing committee report, which had stated that FSSAI please pass a regulation. They had even put out draft regulations and invited comments, but nothing seems to have happened. And the Rajasthan High Court issued a mandamus saying, please draft the guidelines. And it specifically also delineated the regulatory scope between GAC and FSSAI, where GAC being the regulator of genetically modified crops with regards to the environmental impact, while FSSAI would be focusing it from a food safety perspective. Thank you.
Great. Thanks a lot, Bharatwaj. With this, we're done with our first category of developments. And moving on to the second category, we will be talking about the top decisions based on their jurisprudential rigor. For that, we have Ambika, who will be talking about the first decision here.
Thanks, Prash. So the decision of Cryogas versus Inox in the Supreme Court has been landmark in deciding the realm of functionality jurisprudence in Indian design law. Section 15(2) of the Copyright Act says that copyright in an unregistered design will cease when more than 50 articles are industrially produced. But in practical application, in cases we have seen that this is a very confusing distinction between copyright and design. The Supreme Court then tried to clarify this in Cryogas. It gave a new two-prong test. So prong one is to see whether the work is a purely artistic work, or is it a design that has been derived from an artistic work and then industrially applied. And then the second prong is, if it is not a purely artistic work, then is it a design that can be separated from the purely functional aspect of the product. This is great because there has been a lot of back and forth in Delhi High Court, several cases where there have been different decisions on the same section. So the Supreme Court order does give a little bit of clarity. The problem here is that the constitutional validity of this section is already being decided in an ongoing case of Mukul Goyal versus Union of India. And also the DPIIT has this year proposed amendments to the Design Act, where they have said that copyright of 15 years for unregistered designs may be made available even when they are industrially applied. So a lot of jurisprudential confusion here. The High Court is deciding something, the Supreme Court has decided something else, and now we may have a law that turns all of this over on its head again. So a lot of developments still in the design space to look forward to. Back to you, Prash.
Thanks a lot, Ambika. We have Karthik, who will be talking about the next development.
Thanks, Prash. So the first good sign of jurisprudential rigor, in my opinion, is that the court doesn't jump the gun of analysis and moves the steps accordingly. And I think this is what happened in the highly publicized copyright battle between Ustad, Faiyaz, Dagar and A.R. Rahman last year, where the single bench of Delhi High Court had ruled that A.R. Rahman's song Veera Raja Veera was prima facie infringing upon Dagar's copyright in the Shiva Stuti classical composition. However, the division bench has reversed this finding now. The reason being, the court held that the very first hurdle of authorship here could not be cleared by the plaintiff. Now, the plaintiff here, Ustad Dagar's father and uncle, who were the original performers of the work, the court held that there were only proof of their performances of the work and no easily available material that could show them to be the composer of this musical composition titled Shiva Stuti. Now, for the division bench, this was not sufficient to recognize them as authors of that particular musical work. In a sense, the court held that the published CDs and contractual agreements were insufficient to support the case for authorship, and therefore the court very nicely distinguished between a performer and an author. On the second point that I found very interesting and nuanced was that the court undertook an extensive discussion of Indian classical music tradition and observed that how the system is based on Guru Shishya tradition, where, let's say, musical works are passed down orally, and any composition is a product of generations worth of collective creativity. And of course, there are other concerns like there is an absence of fixation here. So modern copyright doctrine might not be sufficient enough to accommodate the nuances of Indian classical music tradition, and therefore the courts have to be very careful in trying to reconcile the two. And I think that the division bench was very cognizant in recognizing that. So that was a great judgment in my regard. The SLP is before the Supreme Court, by the way, and the case is ongoing still. So yeah, back to you, Prahash.
Thanks a lot, Karthik. To discuss the third development in this category, we have Tanishka.
Thanks, Prahash. So this is one of my most favorite IP judgments of the Delhi High Court from 2025. The Pisco judgment, not because I love grape brandy, but because of how Justice Mini Pushkarna undertook a very careful and structured analysis of what homonymous geographical indications are. This is an issue which is rarely examined by Indian courts. For our viewers, homonymous GIs are indications that sound or spell alike, but they identify products or services that originate from different regions. So the challenge here, it was brought about by an association of Chilean Pisco producers, and the challenge was to an order passed by the IPAB in November 2018. This order was in favor of the Peruvian embassy, and herein the board had permitted the registration of the GI Pisco, as in a blanket GI Pisco, in favor of the Peruvian embassy. This was instead of the prefixed tag Peruvian Pisco, which was earlier allowed by the registrar in 2009. Now, the Delhi High Court studied the free trade agreements that both these nations entered into with other countries. The court also studied sections 9A and 10 of the GI Act in detail to conclude that the IPAB order ought to be set aside. Not only do both Chile and Peru have a shared history in Pisco manufacture, registration of GIs, the use of which is deceptive or confusing for consumers, is prohibited by Section 9A. In fact, Section 10 also recognizes that the registrar may allow for registration of homonymous GIs only when they are satisfied of the practical conditions under which both the indications can be differentiated, and that there are sufficient safeguards to ensure equitable treatment of the producers. In my article for SpicyIP, I brought how this debacle compares to the Bangla Rasagolla versus Odisha Rasagolla case, and I've detailed on this procedural irregularities in the Pisco dispute. So I would really recommend viewers to check out that blog post for further details. Now I hand this over to Prahash for the next development.
Thanks a lot, Tanishka. With this, we wrap up the second category of discussion on important decisions on copyrights based on jurisprudential rigor, and we'll be moving to the third category, which talks about important policy-related developments. And the first development in this category is the India-UK CETA, which was signed last year in 2025, with free trade agreements again back in news, with India signing one with EU and then something happening with US where the parties are saying that they have reached a deal but not really letting us know what the nuances of the deal are. Last year, India signed a landmark agreement with the UK where the agreement touched upon a lot of interesting aspects of patent, copyright, GI, trademark. The important issues which stood out from this agreement was the way how Indian negotiators were able to get a better deal from what was initially proposed from the UK's end. So initially, UK had asked India to dilute a lot of its safeguards, which would have impacted the generic industry as well as accessibility of affordable drugs in the Indian market. They had asked India to remove Section 3D. There were a lot of issues which were flagged with regard to the pre-grant oppositions. India was asked to amend its pre-grant opposition provision substantively, and also its safeguards on foreign patent applications under Section 8. Now, although we were able to push back these demands and we were able to make sure that these provisions still exist in the Indian patent law, there were a lot of amendments which were introduced in the executive system in the way how Indian patent applications are examined. A lot of the amendments which were made into the patent landscape in 2023 patent amendment rules could be now traced back to the negotiations or the provisions of this particular FTA. And now with things getting a bit clear, the question is, will this agreement be the template which India is going to follow in the up and coming FTA negotiations that it is going to hold with New Zealand? Or are we going to see something different altogether? So with that question in mind, we'll be moving on to the next development. So Sonisha, please go ahead.
Thank you, Praharsh. So the next policy development is with respect to the amendments which was proposed by MITI to the IT Rules 2021. And this was particularly concerning the synthetically generated information. And the intent was seen to tackle AI generated content and deepfakes. So in our SpicyIP blog, Akshat unpacks this whole move. And it seems to be that the problem with this is not in the intention, but in the execution. For example, Amendment 4, it requires intermediaries to label AI generated outputs, but most of the AI developers may not even qualify as intermediaries under the IT Act. So, how would that play out? Similarly, the definition of synthetically generated material itself. It is so broad that there could be various other harmless uses also that could be involved here. In one of our podcasts on personality rights, Adyasha also specifically talks about the problem with this synthetically generated information and how there's no reference to context when the definition is made. Similarly, Amendment 5 imposes broad verification duties on social media platforms, but there is no definition on what amounts to reasonably technical measures, which brings a lot of confusion over uncertainties with respect to liability. So, overall, this looks to be something where the intent is understandable, but while looking at the enforcement part of it, questions regarding disproportionate burdens without a clear risk based framework. So, over to Tanishka for discussing geographical indication policy developments.
Thank you, Sonisha. Now I'll be discussing the recent amendments of 2025 in the GI rules and also the draft guidelines for the use of GIs and GI logos. Both these were brought about in November 2025. So the amendment rules of 2025 have brought about a principal change. And the first schedule has been replaced with a consolidated fee structure now. This has a comprehensive fee structure with form numbers for every procedural step in the GI framework. And the structure covers applications, oppositions, renewals, etc. There is a notable reduction in the statutory fee across multiple categories, and this is believed to likely encourage greater participation in the GI regime. Now, for instance, the old fee for application of GI registration for one class was rupees 5,000 earlier. Now it has been slashed down to 1,000. And for renewal, it has changed from 3,000 to 500. So significant changes there. And on the draft guidelines on the use of GI logo, there's a significant expansion of eligibility as to who can use the GI name and logo. Now, beyond authorized producers, this includes intermediaries such as dealers, packagers, exporters, and traders who are acting with authorized user consent. Now, this might undermine the traditional philosophy or the foundation of the GI Act. The idea is to protect the collective reputation or traditional knowledge, the livelihoods of actual producers. Now, if consumers are no longer able to differentiate between products genuinely made by artisans and products merely handled or repackaged by middlemen, then it becomes a problem. Dr. Anson brilliantly brings this out in their post on SpicyIP. So I definitely recommend viewers to check the same out. And now I would hand it over to Ambika.
Thanks, Tanishka. So AI has been all the rage in copyright circuits. Naturally, the DPIIT was motivated to say the word. So they have released a working paper. This is the first part of the working paper on generative AI and copyright. What this paper basically recommends is the creation of a mandatory blanket licensing system to which all copyright holders will be subjected to. There is no option to opt out. And in parallel, a new centralized royalty calculation and disbursement mechanism. Even if you see the practical applications of their suggestions, it's easy to see that most of these applications are doomed to fail because they do not stand on strong doctrinal structure. In Silicon Valley, they have this saying that move fast and break things, but we should probably not use this in policy making sensibilities. At SpicyIP, we have several blogs covering this development, and we have also submitted our own comments to DPIIT, which are also available on the blog. We really wait for part 2 of the working paper and see what comes from there, but definitely an interesting space to keep an eye out for. Back to Prahash.
Thanks a lot, Ambika. With this, we will be moving on to the fourth category, which are other developments which were not a part of the first three ones. So we have Sonisha here to discuss the first development in this category.
Thank you, Prahash. So the first development in this category is DPIIT through its CPAM cell has officially rolled out the International IP Moot Court Funding Guidelines 2025. This would be of interest to many students who are watching this podcast. The announcement was made at the inauguration of Viti Pragati. And so basically the aim of this initiative is to support students participating in leading international IP moot competitions by providing financial assistance to these students. A maximum of 10 teams per year would be sponsored under this, and it would be based on a first come first service basis. And per university, there could be only one team who will be eligible as per these guidelines. And universities can either apply before the event or after the event. And the funding right now is available only for certain moot court competitions. So students, please look out for this. Thank you. Now over to Karthik for the next development.
Thanks, Sonisha. So another developing episode from the AI world is of course, the famous ANI news OpenAI litigation, which has been ongoing since, I believe, November of 2024. And ANI news, of course, has alleged that OpenAI was using its copyrighted material unauthorizedly for use and storage for the training purposes of ChatGPT. And there are other allegations also raised. Now, Delhi High Court had framed four interesting issues in this case, which is firstly that whether the storage of the data for training ChatGPT would amount to infringement. Second is that whether the use of plaintiff's copyrighted data to generate responses for its users would amount to infringement. The third issue is around the fair use exception under Section 52 of the Copyright Act. And finally, fourth issue is about the Indian court's jurisdiction to entertain, because that was one of the pleas that was initially raised by OpenAI, that Delhi High Court doesn't have the jurisdiction. Now, Bharatwaj, in a couple of posts, has very nicely given a broad overview of the litigation that has been ongoing. So I would definitely recommend the viewers to check that out. On the happening front, there are a lots of interveners that are involved now because everyone has stakes in this case, including Indian music industry, Digital News Publishers Association, and a couple of others. The High Court had also appointed two amici, Professor Arul Skaria and Adarsh Ramanujan, who gave their submissions to the court last year. We are yet to get access to the reports, but there are media reportage that says that they discussed issues like non-expressive usage, Section 52 concerns, jurisdiction, and whether even the material that ANI News is claiming copyright over, whether that is copyrightable itself or not. As of now, submissions are still ongoing between the plaintiff and the defendants, from what I understand. And we will, of course, are yet to see what decision the court reaches. With the coming of the copyright AI report by DPIIT, of course, the report did not answer the question of whether there is infringement in the training stage or not. But from what the report is saying about, let's say, a blanket licensing mechanism, it will be interesting to see what comes out of the litigation and whether the report has an impact on the litigation or not. The second development that I will also be talking about here is the Memorandum of Understanding that was signed between Screenwriters Association and Music Composers Association of India. Now, this aim of this MOU was to protect the rights of lyricists and music composers and ensure that they have better bargaining power in dealing with music labels and producers. For example, the MOU, from what is reported, will allow directors and lyricists to be considered co-authors in the creation of songs, and both should also be considered primary artists while they're given credits. Because what is often seen is that the singer is often the one who ends up getting all the prominence. So that's something that the MOU seems to address. Secondly, the MOU also stresses on the requirement of separate contracts for music directors and lyricists with producers, wherein both will have the right to negotiate with them independently. Now, how the MOU plays out remains to be seen, because we can also look back at the legal context of how the 2012 amendments to the Copyright Act came into place. Especially lyricists and music composers have come a long way for a struggle for their royalty rights, and this MOU seems to be another step in that regard. The second related development has been the talks of a standard agreement for screenwriters, because screenwriters have also been facing these issues of missing credits, irregular and unfair pay for the work they do, and also unfair indemnity that is often demanded from the screenwriter. So that is also a standard agreement that seems to be in the works. Now, for both of these connected developments, I would highly recommend viewers to read Praharsh and Suhani's post on this, wherein they very clearly unpack both of these issues. And yeah, this is something that I think we will need to see more of it as the development ensures. Yeah, back to you, Praharsh.
Thank you. Thanks a lot, Karthik. Now we have Sonisha who will be talking about the next development.
Thank you, Praharsh. So the next thing that I'm going to be talking about is the launch of Prasad Bharati Shared Audio Visual for Broadcast and Dissemination, PBSHABD. So Prasad Bharati, Doordarshan National and All India Radio, they started offering these free, low-cost, copyright cleared content, which ranges from archival visuals to news clips to audio and documentaries for creators through a feed service called PBSHABD. Now, this is important because it stood as a sharp contrast to what the bigger syndicates would do in respect to, pursuing independent news outlets and YouTube channels through their copyright strikes. So Tanishka and Mohammed Talhir Sulaiman in our SpicyIP blog have written more about this. So please do check that out. And this move becomes very important. It's a one step towards providing access to archival visuals and news clips and resources which earlier were locked behind paywalls. So, with respect to more access to news material and content, especially for creators, this seems to be a step towards that. Over to Tanishka.
Thanks, Sonisha. So this last development on fashion, I hope to conclude this episode in a fashionable way. The Prada Spring Summer Collection 2026, it sparked controversy all over the country because it was alleged that they are appropriating the GI tagged Kolhapuri chappals, and this drew attention to issues of fashion plagiarism. There was significant social media backlash also. And the question which arose was there GI infringement? And the answer is a big no, because Prada did not use the Kolhapuri chappal GI in its designation or presentation of the summer collection to suggest or mislead people on the origin of the Kolhapuri chappals. And Prada also did not infringe the exclusive right under Section 21 of the GI Act, which is granted to authorized users of the Kolhapuri chappal to use such indication in relation to the protected footwear. So, in other words, Prada as an entity that is not an authorized user under the GI Act never claimed that its footwear collection includes the Kolhapuri chappals. In fact, the Bombay High Court in July 2025 also dismissed a PIL which was seeking action against Prada for this alleged plagiarism or copying. And the entire issue brought about the limitations of GIs. Even when they are commercialized, the concept in itself has been inadequate in protecting collective rights. And there is very limited trickle down effect to the small scale artisans and little benefit from the cultural appropriation of traditional Indian knowledge also. So we are witnessing how a sui generis GI regime is grossly insufficient in protecting anything except the registered product's name. So there is a brilliant podcast on this issue, which our very own Sunisha has conducted, where Niharika Salar brings out some very significant insights on the limitations of GI from her field work in India. So definitely, please have a look at that also. Thank you.
Thank you. Thanks a lot, Tanishka. And thank you, everyone. With this, we'll wrap up the discussion on important IP developments from 2025. For people who are interested to read on these developments, they can check out our report on the blog and also multiple blog posts that all our panelists mentioned in their discussion. So with that, I'll take your leave. Thank you. Thank you so much.